Hello everyone and welcome to BYJU'S. And welcome to another episode of Weekly Current Affairs. Now in this video, we will be discussing about the newly introduced and almost passed the Criminal Procedure Identification Bill 2022. I say almost passed because this bill has been passed by both the houses, the Lok Sabha as well as the Rajya Sabha, and is awaiting the assent of the President of India. So this was introduced on the 28th of March and was passed in the Lok Sabha on Monday, was passed by the Rajya Sabha a few days back, and is awaiting the assent of the President, as I said. Now, as far as the bill is concerned, from the moment that this bill was introduced, it has been marred with controversies from various quarters. Lot of issues have been flagged, lot of allegations against the government. So this bill is seen as slightly controversial. So in this video, we will try to decode as to what are those issues and concerns that have been raised from various quarters, the opposition parties, also the civil society activists, as well as other members of the communities. So in this video, we'll start off by understanding the provisions of the bill, and then we'll also move on and see the issues concerned and what has been the response of the government insofar as this bill is concerned. But before we delve into understanding the provisions of this bill, we'll have to also firstly understand another bill or another law in the country which already exists. This new bill is going to replace an already existing law in the country, and that law is the Identification of Prisoners Act 1920. Henceforth, I'll refer this to as the IPA 1920. It's a 102-year-old law, a British Indian law, and this is the law which is currently in force. So as and when the CRPC identification bill becomes an act after the notification, this old law is going to be repealed. So the new bill replaces this old law. In order to appreciate the reasons for the new bill, in order to also understand the provisions as well as the issues and concerns, we also have to have a basic understanding of what the original law is. It is a small law. It just has 9 sections. So let's see this law first. Now, the purpose of this Identification of Prisoners Act was to take measurements of convicted and even non-convicted persons by police officers. So what exactly is this measurement that we are taking of convicted and non-convicted persons? So this measurement was, number 1, fingerprint impressions or even the footprint impressions. So this was the measurement that this law allowed the police officers to take. Beyond this, the police officers could also take photographs. So when you have a chance to visit a police station, you will find out that there are some boards where you have some photographs stuck. So this is how the police is authorized to collect photographs, collect fingerprint impressions as well as footprint impressions. So measurements of these categories are allowed by this law. Secondly, the law says that the convicted persons and non-convicted persons are the ones whose measurements will be taken. So who exactly is a convicted person? According to this law, any person who has been punished with an offense, committing an offense where the minimum punishment is a jail sentence of at least 1 year or above, and that too a rigorous imprisonment, meaning you should be punished of committing an offense of at least 1 year of jail sentence with rigorous imprisonment. Or you can also be arrested, somebody who has been arrested for or under an offense where the minimum punishment is 1 year of rigorous imprisonment, they are under the category of non-convicted persons, and their measurements can also be taken by the police officers. Beyond this, there is also one section 117 under the CRPC 1973. Now, what is this section 117? This section 117 basically says that, in every area there are some kinds of mischievous elements, and sometimes the magistrates, the executive magistrates like the district magistrate, the sub-divisional magistrates, they can issue an order and ask these mischievous people to give a sort of security, a security ensuring good behavior, a security ensuring that you will be a good boy, a good girl, whatever pronouns you may choose, and you will not misbehave, you will not hamper the public order in that area. So you have to give some kind of a bond, some kind of surety so far as your behavior is concerned. So all those people who have been asked by the magistrate to give a security of good behavior are also covered under convicted persons, and your measurements like fingerprints, footprints or photographs can be taken. Now beyond this, the police officers. So who are the police officers? The people who are authorized to collect this measurement. So under the law, all people who are of the rank SI or above, sub-inspectors or above rank police officials are the ones who are authorized to collect this measurement. So these are the three words that are important. Now beyond this, who authorizes these people? So the authorization comes from the magistrate. It could be a judicial magistrate of first class, or it could also be an executive magistrate. Executive magistrate means a district magistrate or a sub-divisional magistrate. Now, the magistrates have comprehensive power to issue orders asking people to come and provide their measurements at any time, any place. So it has wide powers. Wide powers have been given to the magistrates to issue orders for any person to come at any point of time at any given place and provide for the measurements. So let's say you are from Tamil Nadu. The magistrate can issue an order and say, please go to Assam and give your measurements. That won't happen, but the ambit is very wide. And beyond this, the magistrate also has the power to tell you to come and give the measurements, but also to ensure that the measurements are captured by any means necessary. So the police officials can employ any means necessary to collect or capture your measurements. Now, what if you are somebody who feels you are camera shy, or maybe you have seen your photographs on your Aadhaar card, voter card, you say, no, I won't get a photograph clicked without a beauty filter. And you say, no sir, no ma'am, I cannot get a photograph clicked. In this situation, what you're doing is actually resisting, refusing to cooperate. And under IPC section 186, if you obstruct any public official from conducting or performing his public duties, it is actually a punishable offense. So you now, because you are obstructing a public authority from performing his public functions, will be punished with a jail sentence which can be as high as 3 months, up to 3 months of jail sentence, or a huge amount of rupees 500. So either jail sentence or fine or both. So you are trapped. If you refuse to give your measurements, you will be punished under this particular offense section 186. Now, beyond this, the records will not be kept. They will be destroyed. The negatives, the copies, every record of yours that has been collected will be destroyed if you have been acquitted. So when the matter goes to court and after the trial takes place in the court, and if a rich person, if you are somebody who is not guilty, then you are acquitted by the court. If you are acquitted by the court, then your records will not be kept. Or if you are discharged by the court, or you are released without trial. Meaning, sometimes when the police arrests you, they want to prepare a charge sheet, they want to take the matter to court, but because of lack of evidences against you, they may have to drop the case. So the case may never go to trial and you are released without trial. In all these circumstances, your records, your measurements will not be stored, they will be destroyed. But there is an exception. The exception is that if the court or the executive magistrate feels that it is necessary to have the records of the person, then your records will be kept with the government. Now, when the court issues such an order that despite you being acquitted, despite you being released without trial, why should the records be kept? The court or the magistrate will have to give reasons to be recorded in writing as to why the court feels the need to still preserve your records despite you being acquitted, or the executive magistrate still feels the need for the records to be preserved despite you being released without trial. So this is with respect to destruction of records. Now, coming to rules. Whenever a law is passed, the laws are passed by the legislature. And legislatures can't delve into details of a law. A law is a bare skeletal form, right? It is the rules which provide the flesh and blood to the law. For example, under the Motor Vehicles Act 1988, there is one section 127 which says that if you want to go out and drive a two-wheeler, you need to have a protective headgear. It is mandatory. Now, this law does not comprehensively define what is protective headgear. They simply say, or the law simply says, that any kind of headgear which ensures safety. Now, what if you go out on the road and wear a birthday cap or a paper helmet and say, sir, this is what provides me with safety, this is a magical cap? The rules have to be enforced, have to be implemented to tell us what is the material that can be used for the helmet, what quality, what size, what color. So all these things are done via rules. So laws are basically implemented via rules. Now, to implement this law, the IPA, the Identification of Prisoners Act 1920, state government will make rules. Will make rules with all aspects, including any kind of provision, how to apply the law, including deciding on the time, deciding on the place wherein the measurements have to be taken, deciding on the dress code. Let's say you are a Ranveer Singh fan, you say, no sir, I want to come in this dress only and I want to get my photograph clicked in this dress only. But the government can decide on what is the appropriate dress code to be worn while getting a photograph clicked, including things like safe custody of records, preservation of records, maintenance of records, dissemination and distribution of records. So all aspects of data keeping and data collection are to be decided by the state government via the rules. And the very basic fact is, whenever the state government makes any rule, it has to also table these rules in front of the state legislature. It is mandatory to place these rules in front of the state legislature, which then approves the rules. So this basically is the original law, the IPA, the Identification of Prisoners Act 1920. Now, a need was felt to modify this law, or rather replace the law completely. So the government introduced something called the Criminal Procedure Identification Bill 2022. Now, whenever a bill is tabled in the House, the government has to give us a statement of objects and reasons, SOR, statement of objects, as to what is the objective of the particular proposal and what are the reasons as to why the bill has been tabled in the first place. So the Minister of State for Home Affairs, when he tabled this bill in the Lok Sabha, he said that, in our country, and especially if you compare our country with advanced countries, in advanced countries, new methods of measurements are being incorporated, which are giving good results, a higher conviction rate. So in our country, the existing rule, the law has two problems. Number one, limited measurement. We have to take more measurements. As of now, we are only allowed to take the fingerprint and the footprint impressions with photographs. But again, in most advanced in Western countries, they take various kinds of measurements which are used to nab the culprits. The second issue was limited category of persons whose measurements can be taken. So as of now, measurements can be taken for convicted persons, where the definition says that you have to be convicted of an offense, where the punishment is at least 1 year of rigorous imprisonment, or the same for the non-convicted persons. Again, the government said that the ambit of this person has to be widened, because the real problem that police faces sometimes is the lack of evidence. And since the laws are inhibiting in nature, the police is not able to collect proper evidence, which then results in the failure of the case in the court, resulting in the acquittal. So to also ensure that police is able to collect legally admissible evidence and ensure a higher conviction rate. See, as of now, our conviction rate is pretty decent. It's roughly 74% across the country. And we want to increase the conviction rate further, ensuring that at least that whenever the police catches some accused, they do not falter, at least along the lines of finding some concrete evidence. And you know, recently a very interesting movie was released on the OTT platform called Salute. It talks about the police procedurals starring Dulquer Salman, as to how sometimes the police is forced into planting evidences because of the challenges in evidence collection. In fact, a very famous movie called Visaranai was also released a few years back, which talked about the similar issue, where the police sometimes has to create evidences, force the accused into accepting the mistakes. Thus comes the third-degree torture. So we'll avoid all these things. The best way is to collect proper concrete evidence and ensuring that police also works freely, because when a crime is committed, there is a lot of pressure from the media, a lot of pressure from the politicians to get quick results, especially before elections, which results in the police sometimes resorting to third-degree torture. And the Home Minister said this in the House, that this will reduce the need for third-degree torture in the country. That's a very strange reason, but nevertheless. So these are the reasons why the government says we need a comprehensive bill. So the new CRPC identification bill was introduced. The bill had this purpose: authorizing what? Taking of measurements of convicts that we had earlier also, and other persons. Now that's a very weird phrase. Other persons does not really mean some specific category. Let's see what this means in the coming slides. For the purposes of what? Number one, identification, and number two, investigation in criminal matters, plus preservation of record. So now we'll also look forward to creating a database of sorts along the line of Western countries to ensure that there is a strong database, a network of information which can be utilized to nab criminals quickly. So this is the purpose of the new bill. Now under this bill, the definitions kick in. First definition is of measurement. So what exactly is measurement now? Remember earlier, the measurement meant only two things: the fingerprint and footprint impressions and the photographs. But now measurements would mean finger impressions, palm print impressions, footprint impressions, photographs, iris and retina scans, physical and biological samples. Now they have not defined what is a physical sample, what is a biological sample. See, biological sample or physical samples would mean things like saliva, blood sample, DNA, semen, hair clippings, fingernail clippings. All these things can be construed to be a part of physical and biological samples and their analysis. Then behavioral attributes like signatures, handwritings, possibly voice samples, and other examinations. So you see how comprehensive is the definition of measurements now. So now it has become very invasive. A lot of measurements can be taken by the concerned police officials. First thing. Secondly, the definitions of convicted and non-convicted persons. See, one thing is common, that section 117 of the CRPC, meaning if you have been asked by the magistrate to issue a security, a bond, a surety of sorts of good behavior, then your measurements can be taken. All possible kinds of measurements can be taken. That's there. But beyond this, now there is a modification. Originally, the law said that measurements will be taken only for the people who are either arrested or are convicts of committing an offense where the punishment is minimum 1 year of rigorous imprisonment. Now, the new provision says that we will take measurements of any person who is convicted of any offense. Any offense in this country, the moment you are convicted, the moment you are arrested for committing any kind of offense, whether it is as gruesome as killing somebody or maybe rash driving, jumping the signal, we don't know. So, any kind of offense, the moment you commit any kind of offense, your measurements are liable to be taken. Same thing, if you are arrested for committing any offense, your measurements can be taken. And one more addition, if you are arrested for or under any preventive detention law, under Article 22, the rights which are given under Article 22 can be taken away for certain categories of people, enemy aliens or people who are arrested under preventive detention laws, even before the commitment of crime if the police arrests you. So under any preventive detention law, and mind you, PDLs, the preventive detention laws can be made both by the central and the state governments. Why? Because this is a concurrent list subject. So if you are arrested under any preventive detention law, even then all possible measurements of yours can be taken. Second thing is the definition of measurements, the convicted and non-convicted persons. And finally, the police officers. Now in the original law, the police officer was of the rank of SI or above. It has been reduced now. The rank has been lowered. So now the police officers would mean either head constable, or in case of prison authorities, it would mean a head warder, not warden, W-A-R-D-E-R, warder. Warder simply means a guard. So in the jails, you have IG, the IG of prisons, then you have the DIGs, you have the AIGs, then you have the special superintendents who you call the jail superintendents, then you have jailers, you have assistant jailers, you have chief head warder, then comes the head warder and then the warder. So you can see how the law has, the bill rather, has lowered the level of police officers who can now take your measurements, possibly all sorts of measurements. That has widened the ambit amazingly. Then, the manner in which these measurements will be taken will be prescribed by not just the state governments, but also the central government. So in the original law, only the state governments were allowed to make rules with respect to capturing this information. But in the present law, the central government is also allowed to make rules with respect to how to implement this law effectively. Then, exceptions. Now, yes, exceptions are there under this law. What is the exception? The exception is that biological samples can be refused. So if you are arrested for any offense, you can refuse to give a biological sample. But there is also a challenge here. The challenge is that if you are arrested for committing any offense where the punishment is at least 7 years, then you will have to give your biological sample. Or if you are arrested for committing any offense which involves women or children, even then you will have to give your biological sample. Beyond that, you can refuse to give your biological sample, complete exception from giving biological samples, but then under these two circumstances, it becomes mandatory. You will have to give the biological sample. And when it comes to storage of data, remember the purpose also was to store data. So now the data will be stored by NCRB, the National Crime Records Bureau, which is under the Ministry of Home Affairs. So this is now going to store the data. So it will collect data, store data, preserve data, process the data, disseminate and share data with other law enforcement agencies. So the storage of data has been controlled now by NCRB, a central government agency or a body. Now coming to maintenance of records. The records will have to be maintained in a digital or electronic form for 75 long years. That's an entire lifetime. So your records once captured will be maintained for 75 long years. Yes, obviously, if you are acquitted, if you have been discharged, or if you have been released without trial, under all these circumstances, your records will not be kept, they will be destroyed. But again, the same old story, that if the judge feels, if the executive magistrate feels that your records need to be kept, then your records will be kept. But yes, they have to give reasons in writing why they still feel that your record needs to be kept. But otherwise, if you are convicted of any offense, even a minor offense, your possibly all kinds of measurements can be taken and can be stored for as long as 75 years. Then coming to magistrate's power, a very unique provision in this bill. See, so far we have seen that if you are accused of an offense, arrested in an offense, or if you are convicted of committing a crime, your measurements will be taken. But under the provisions, the magistrate has a power to order or direct any person, you, me, anyone, to give their measurements, whether you are directly related with the case or not. The magistrate, if he or she feels that by collecting your measurement, it will aid somehow in the investigation, and he has to or she has to prove it to no one. It is his or her subjective opinion that by collecting your measurements, it will help in aiding in the investigation. Your measurements can be collected. As simple as that. So practically, this law covers everyone. Everyone's measurement can be taken. Whether you are directly involved in committing a crime or not, your measurements can be taken. This gives wide powers, sweeping powers to magistrates, and this means the government to collect information. And again, you know very well, if you say that no, I won't give my photograph, I won't give my measurements, I won't give my fingernails, I just had a manicure done, pedicure done, I can't give my fingernails, then you know what? You are obstructing a public official in the performance of his functions, his duties, so you are now punishable under section 186. Resistance or refusal to cooperate with a public official in the performance of his public functions, which means what? 3 months of jail or ₹500 of fine, or both. And interestingly, if you are accused of committing any crime, then you have to give measurements. So the police can come, randomly ask for your measurements. If you refuse, what is happening is you are now accused of committing a crime, an offense, section 186. This means now you are an accused. This means now the police has comprehensive authority to collect your measurements till you are acquitted. That's a long duration. In our country, the average pendency in the court system is 15 long years. That's an average. In the Supreme Court itself, it takes roughly 4 years for cases to see the light of the day. So for 15-20 years, your data can be stored with the government officials. So this is again a sweeping power given to the government officials. And then coming to rules and regulations, in the original law, the rules were to be made only by the state governments. Here, the rules will be made both by the central as well as the state governments. Both of them are allowed to make rules. There's a small catch here. When the central government makes rules to implement this new bill, those rules have to be tabled in front of the parliament within 30 days of the session. within 30 days of the rules being made, you have to table this particular proposal in front of the parliament. Whereas for state governments, if the state government makes any rule, it has to table the rule in front of the respective state legislature at the earliest possible opportunity. So no such 30-day time frame for state governments. Now beyond this, the government has also said under the same new provisions that whenever you implement a new law, it can have some difficulties, especially with respect to collection of data, information. It has such wide ambit that the government says we might face some difficulties. So in order to remove difficulties which we may encounter while implementing the CRPC identification bill, the central government can issue any order to remove difficulties in the implementation of this bill. But yes, those orders can only be issued within 3 years from the date of passage of the bill. So let's say the bill is passed today finally. So the central government can issue any order to ensure that the law is implemented effectively across the country till the year 2025, say 8th of April or 7th of April 2025, the central government can issue any kind of order, right, to remove difficulties. So this is the new CRPC Identification Bill 2022. Now coming to the issues and concerns as far as the bill is concerned. So what are those issues? What is the real problem with this particular bill? First things first, the law is loosely worded. When you say, what is the meaning of physical sample? What is the meaning of biological sample? Yes, we have a broader understanding that a biological sample, a physical sample could mean blood, hair clippings, fingernail clippings, semen sample, saliva, etc. But still, there should be a categorical definition. What is a behavioral attribute? Is it, or does it also include voice samples? So since these words have not been defined, it provides an arbitrary power to the government. Now, the measurement definition also said not only collecting physical samples, not only collecting biological samples, but also analysis. Analysis of those samples. What do you mean by analysis? Does it mean that now the government, the police officials can go for something called narco analysis? Can they go for brain mapping? Or something called a polygraph test? All these things, can the police officials now go for all these things? Narco analysis is, just to give you an example, basically, a truth serum is injected, something called sodium pentothal is injected in your body. It kind of slows down your central nervous system. It induces some kind of hypnosis, and then you blurt out the truth. It's just like, when you drink too much, you start blabbering uselessly. The same thing happens here also. But do you remember that we have something called Article 20? Article 20 has 3 provisions. Number 1 is that there will be no ex post facto law. Number 2, no double jeopardy. Number 3, no self-incrimination. Nobody can be forced into being a witness against himself or herself. But here, under this provision, there was a Selvi case. Selvi versus State of Karnataka in the year 2010, where Supreme Court has already said that narco analysis, brain mapping, polygraph tests and tests of similar nature cannot be conducted without the permission of the accused. But this entire bill nowhere talks about the permission being taken from the accused to analyze the physical samples. That's a challenge. It comes into direct conflict with the Selvi judgment. Now, the Home Minister in the Rajya Sabha had mentioned this statement that don't worry, the police officials will not conduct these kind of tests. But we know there's a huge difference between what the minister says in the house, on the floor of the house, and how rules and regulations are implemented in the country. So a better thing would be to define these words very, very clearly, to remove any kind of subjectivity in the law. which has not been done. That is why the possibility of violation of Article 20 Clause 3, no self-incrimination, plus direct violation of the Selby judgment of 2010 is also possible. Secondly, conflict with other laws. Now, when you make a law in the country, don't you think it is very, very important to have some kind of impact assessment? When I make a law, will it have an impact on other laws? Will the provisions of the new law be in contravention or be against other laws? Then such provisions should be modified. We cannot simply pass any law. There are so many laws in this country with so many provisions. So when you make a new law, you have to be very, very careful that the provisions do not come into conflict with other existing laws in the country. Either you modify the new law or you modify those provisions which are in conflict. This has not happened. To give you two very interesting examples, under CRPC 1973, there is one section 53. It says that the sub-inspector or above, police officer of the rank sub-inspector or above, can conduct an examination, without defining examination, can conduct an examination on reasonable grounds, that the examination of the person will afford some kind of evidence. On those grounds, examinations can be conducted, but examination only by an officer of the rank sub-inspector or above. And number two, you have to give reasonable grounds. In the new bill, there is neither the mention of any reasonable ground, and the official's rank has also been lowered. So this directly comes into conflict with an already existing provision which states the otherwise. That's a problem, that's a challenge. Or for example, the government itself had introduced a DNA technology use and application regulation bill 2019. Now this bill says that when we take the DNA sample, consent will be required. It's mandatory to give consent. The only exception here is if you are punished or if you are accused of an offense where the punishment is either life or death or 7 years or above of jail sentence. So in such circumstances, you will have to give your DNA sample, but beyond that, consent is required to collect your DNA sample. But under this new provision, there's also one more challenge. The biological samples can be collected even when you are accused of a crime against women and children. Again comes into conflict with the already existing proposal, a bill brought by this very same government. Conflicts, contradictions in itself. Then, who can give orders? You know, back in 1980, the Law Commission was set up to look into the original law, the IPA 1920, and give some recommendations. That Law Commission gave a recommendation that the SIs and above, the police officials, should give reasons as to why they are collecting your measurements. But in the new law or the new proposal, new bill, no such recommendation has been accepted firstly. Secondly, you have gone ahead and lowered the level of police which can now collect the evidence. I would not say a petty official, but an official of very lower rank now is allowed to collect your measurements. That's also a problem, right? Because the ambit is so wide that we have to give proper surety, assurance to people. For any offense, your measurements can be taken by officials who are as low in rank as head constables or head warders without giving any reason, which is in direct contravention to the Law Commission recommendations almost 42 years back. Then comes the dreaded provision. From whom can data be collected? First things first, data can be collected for any kind of offense, whether it is jumping the signal or it is killing someone. Now, these two offenses are extremely different in nature. They are completely opposite. How can you have a wide law which covers practically everything? This is giving too much power to collect and store data, number one. Number two, any person, whether you are somebody who is related to the case or not, whether you are somebody who is acquitted, or whether you are somebody who is convicted, whether you are somebody who is arrested, any person's data can be now captured. Why? Because if the magistrate feels that somehow by capturing your data, it will help me in the investigation process, without giving any reasons as to how this will help us in the investigation process. That's extremely stretching the limit a bit too much. This again comes into conflict directly with right to privacy. If you remember, under Article 21, in 2017, there was the Puttaswamy judgment, Justice Puttaswamy case, wherein a 9-judge bench with a 9:0 majority had said that right to privacy is integral part of Article 21. Article 21 is the most important fundamental right. And herein, the government is collecting all sorts of possible measurements from all the people of this country. And where is the data protection law in this country? Without even having proper data protection laws in the country, the government is going ahead and collecting information without providing any kind of assurance as to how it will ensure the protection of data. This directly infringes on right to privacy. You are going to collect measurements from every individual practically, whether he or she is related to any case or not. Where is the privacy? It again directly comes into conflict with the Puttaswamy case under Article 21. One more very, very serious issue. And beyond this, also understand that when we say biological samples are being collected, rightfully, biological samples can be refused to be given. You can refuse to provide your biological samples, but. The problem comes when you say that the moment a person is convicted of an offense or arrested, accused of an offense against women or children. What kind of offense? Ideally, it should have meant some sexual offense, an offense of serious nature. But this word offense is very vague. It can also mean chain snatching. So imagine a situation. A woman walking down the street and somebody snatches her chain. Now you are forced into giving a biological sample because practically and logically it actually is covered under this particular law because you have committed an offense against a woman. And to take into account another example, if let's say there is some person, a Bappi Lahiri fan who is wearing 10 kgs of gold and is walking down the same street, and if you snatch his chain, then you need not give a biological sample. So this also violates the basic tenet of Article 14. Article 14 talks about two aspects: equality before law, equal protection of laws, meaning like should be treated alike. There should be reasonable classification. When you treat people differently, the classification has to be logical. It should be based on intelligible differentia. You should place people under similar circumstances in the same group. Why are you treating women and men differently for such a vague word called offense? So ideally, we should have modified the meaning of this word offense here also to include offenses of a sexual kind or for a grave nature. This random vague word of offense makes it a bit too arbitrary, which can again be a challenge to Article 14. This is yet another problem with the law or with the bill to say. Then data retention. Now, there is something called right to be forgotten. Though in India, we don't have this concept as of now, though government on various occasions, the central government has given submissions in various high courts that yes, right to privacy under Article 21 also ensures right to be forgotten. It's a very European concept. Just to give you an example, let's say a few years back, you were a fan of TikTok videos and you made some cringe-worthy TikTok video, but now you're too ashamed. You want to remove this video and you remove the video, ask TikTok to please take it down. Because 30 years down the line, let's say you are trying to teach your kids, asking them to study, and your kids show the same video that mom, dad, this was you. So to avoid such embarrassments, you may ask the concerned authorities to take down the video. Right to be forgotten. And the same thing can be applied For various cases, let's say you are somebody who was convicted of a very minor offense, say theft, but now you have improved, you have mended your ways. Why should the information be there online with the government for the next 75, 80 years for a petty offense? We understand that information of a sensitive kind, let's say somebody who was involved in some terrorist activity, somebody who was involved in committing a sexual offense, yes, their data should be stored for a long duration to keep a check. But for petty offenses, why should the government feel the need to store data for 75 long years? Every individual has a right to be forgotten. You should be given another chance. So it also comes into conflict with the very basic tenet of right to be forgotten. That's also there. And beyond this, understand. Now, yes, we know that the CRPC, the criminal procedure and such other laws are under the concurrent list entry number 2. So yes, the center and the states both can make laws. But we know very well that the Sarkaria Commission, the Justice Ranjit Singh Sarkaria, or the Madan Mohan Panchi Commission, both these commissions had said that ideally the central government should not make laws on concurrent list subjects. Let the states make laws. But herein the center has jumped in and has made NCRB the nodal agency to collect all information and to disseminate information. And tell me frankly, where will NCRB store data? Does it have the manpower? Does it have the resources? The bill does not talk about anything with respect to any kind of budgetary allocation. There is no mention of any kind of budgetary allocation towards storing and preserving and protecting this data. So how are we assuring the citizens of this country that your data will be in safe hands? There is no guarantee. So these are the issues and concerns insofar as the new bill is concerned. Now the bill has already been passed, right? It's, as I said, awaiting the signature of the president, which is going to happen in all likelihood. There is one small saving grace. That's an expectation, a hope. On the floor of the House, a lot of MPs had raised all these concerns. But the government promised them that don't worry, in future, when we implement the law, when we make the rules to implement the law, all these lacuna, the shortfalls, the shortcomings, the loopholes will be removed, will be taken care of, will be weeded out. Again, that's something that we have to wait. Only time will tell whether the law is implemented as it is, or there are categorical definitions as far as the words like measurements, biological samples, storage of data, and all such things are concerned. So we will have to wait for the rules to be formed and hope that this does not infringe on the right to privacy of the people of this country. So this was all that you needed to know as far as the CRPC identification bill was concerned. That's all for this video. Jai Hind.